So, Vincent, what are the legal implications of the court's refusal to grant Senator Anyanwu's ex parte request, and how might this impact the position, his position within the PDP?
Yes, the position of the court refusing to grant the ex parte order restraining INEC from giving recognition to Ottaokpukpu as the substantive secretary of the PDP is well founded in law. Under Order 26 of the Federal High Court Rules 2018, Order 6, Rule 6 specifically provided that an application can be filed, a motion can be filed ex parte, asking the court to do XYZ when there is an immediate danger that the subject matter may perish, or when there is an urgent issue or a matter of urgency. In the context of this, the court can hear the application. Now, under Order 26 to 7 of the same rules, the court can refer the application and say, "Oh, I don't need that. There's no urgency to grant here. Go and put the other parties on notice, as it were." Now, the position of the court refusing such application is commendable. Is founded in law. It is in line, intended with our nascent democracy and the new need to give fair hearing to the opposing party. Section 36 of the Constitution has granted the right to fair hearing, and that right to fair hearing presupposes that where a person has been accused of anything, the person must be given right to be heard, right to state his own side of the story, as the case may be. So there is no urgency, there's no perishable tomato or pepper that will warrant that if the court does not give it, something drastic will happen. It is just an office, and INEC has been put on notice to come and show cause, as the case may be, when the motion of notice will be heard. You must know that the leadership squabbles respect to the National Secretary of PDP started when Anyanwu, when then substantive secretary, vacated office to contest the office of the governor of Benue State and lost. Nature abhors vacuum. The PDP Southeast caucus and what have you, deliberated, and the National Working Committee, as the case may be, accepted the recommendation of Ottaokpukpu as this to replacement as substantive secretary. Anyanwu lost the governorship bid and decided to come back to say, "No, I'm still the substantive secretary," when nature abhors vacuum. Now, Ottaokpukpu went to the Enugu State High Court, got an order in 2013 December that affirmed him as the substantive secretary of the PDP. Now, in January 2014, Anyanwu went to the FCT High Court, the High Court here in Abuja, and got an order declaring him as the still substantive secretary of the PDP. But Anyanwu went to Enugu and appealed against the judgment of Enugu State High Court, to the Court of Appeal, Enugu State, that in December 2014, the Court of Appeal affirmed the judgment of the lower court, the High Court of Enugu State, that pronounced Ottaokpukpu as the substantive secretary. Anyanwu now appealed to the Supreme Court of Nigeria, which appeal is still pending, as the case may be. But a motion for stay of execution was filed by Anyanwu at the Court of Appeal, which was transferred to be heard at the Court of Appeal at Abuja here. And the appeal court did not hear and grant any stay of execution, as it were. So the valid subsisting judgment of the court on the subject matter as to the National Secretary of the PDP is that of the Court of Appeal of Enugu State, that have conferred the rights and benefit on the Ottaokpukpu, of which INEC must obey. Because every judgment of court confers on a successful litigant benefit, rights, interest, and obligation. Because the litigation is like a contest, pending when the appeal at the Supreme Court is determined, as the case may be. Entering of appeal at the Supreme Court or Court of Appeal does not operate as a stay, unless there's express order of a Supreme Court or Court of Appeal granting stay of their judgment or order as a case may be.
Vincent.
Section 18 of the Court of Appeal Act, which is in consonant with Section 7 of the Supreme Court Act, is in line with this.
Vincent.
So the order of the Federal High Court, Abuja, my Lord, the Justice Ikpembese, is well founded and in law. Let the parties come to court.
All right, now, Vincent, just a second, Vincent. Just a second, Vincent. Now, that's very grand, and thank you very much for giving us a step-by-step how this is all happens. But how does this case reflect internal power struggles within the PDP? They're not proving to be such a powerful opposition at the end of the day. How is this going to reflect on the followers of the party, or even the internal members of the party, as they see the squabbles happening for leadership?
I agree with you. The situation does not represent, it does not portend the PDP in a good light, because they will continue to lose a lot of membership and as the case and stewardship and as the case may be, because as a viable opposition they're supposed to be, which they are not. They're supposed to put their house in order. 2027 general election is around the corner. There should be that internal party discipline, internal party democracy, which the PDP constitution also provides, and the 1999 constitution. PDP no need to put their house in order and must be able to call a spade a spade. The National Working Committee and National Executive Committee of the party have already endorsed the office Ottaokpukpu as the National Secretary of the PDP, and that is a way to go, in line with judgment of the court. And INEC is enjoined to accept that as the position of the law, pending when the suit before the court is already determined. But you must know, Supreme Court appeal is already at the Supreme Court, and by section 235 and 2 of the Constitution, Supreme Court is the highest court in the land, as the case may be, as a policy court.
Now, Vincent,
so which I know, once Supreme Court gives judgment on that subject matter, it will bind everybody, and that will put to rest the squabbles.
All right, Vincent, what about the allegations that are about the ruling party actually having a hand in the squabbles of the other parties, like, for instance, in this case, the PDP?
These are all allegations, whether founded or unfounded. But in every allegation, there may be some witty truth. But the truth is that in most cases, when you have a ruling party that want to clinch to power in subsequent elections, there is every indication that they will do everything humanly possible to retain power, which includes but not limited to disorganizing, disorienting the activities of opposition parties, so as to put them in a state of quagmire, in a state of confusion, so that they will not be able to get their feet together to be able to launch a credible opposition. So there may be some witty truth in those allegations and the assertion and the accusation. APC is a ruling party. They also need to do well. You don't need to, as the case may be, disorganize as the accusation portends other political parties to be able to win the next election, because the mandate lies on the people. So it's whether founded or unfounded, the allegations are there. But the PDP need to put their house in order and do more, so as to win the mandate of the heart of the people before the 2027. These activities, all these leadership squabbles will not take them anywhere.
All right, now, Vincent. Let's leave the PDP National Secretary Saga for a minute, and let's talk about the removal of the judge. What are the legal and constitutional implications of the Benue State House of Assembly's removal of Chief Judge Maurice Ikpembese, especially given the opposition from some lawmakers?
Yes, I received with shock, with utmost dismay, the news of a purported removal of the substantive chief judge of Benue State. Such a purported action, which amounts to what I'll call legislative rascality, is not an abuse. Is not only repugnant to natural justice, equity, and good conscience, but inconsistent and incompatible with the provisions of the Constitution, especially Section 292 of the Constitution, that are outlined the procedure for the removal of a chief judge of a state. Take it this way: Section 153 has provided the establishment of National Judicial Council of the Constitution as a body responsible for appointment, promotion, disciplinary action against judicial officers in Nigeria. Under Section 271 of the Constitution, it says that the appointment of the chief judge of a state shall be done by the governor on the recommendation of the National Judicial Council, subject to confirmation by the state houses of assembly. Now, under the law of master and servant labor law, he who hire cannot fire. If the law has provided that the only procedure to appoint his chief judge is by the appointment by the governor on the recommendation of the NJC and confirmed by the state assembly, it is also related that the procedure to remove the governor of the chief judge, as it applied in the section 292 of the Constitution, requires the concomitant participation and intervention of the NJC. Now, the procedure under that section says that a judicial officer shall only be removed from office, cease to be in office or removed from office in the case of a president, in the case of Chief Justice of Nigeria, or Grand Cadi, or President of the Court of Appeal, or Chief Judge of Federal High Court, or City High Court, as the case may be, by an address by the President subject to two-thirds majority completion by the Senate. Now, that is A sub II. Then II too says that in case of Chief Judge of a state, Grand Cadi of the Sharia Court of Appeal or Customary Court of Appeal of a state by an address by the Chief Judge, by the governor, submitted by two-thirds majority of the State Assembly. Now, there's a proviso that provided that in any case, the National Judicial Council shall be able to investigate activities of the said erring judicial officer for offenses for purposes relating to that the person is having affinity of mind and body, so that he is not capable to discharge the functions of his office, or being accused of corruption or a breach of code of conduct, as the case may be. In the context of this, the NJC must carry out the onerous duty of investigating the fellow and make a recommendation. Now, the principles of natural justice enshrined in Section 36 of the Constitution require that when a person is accused, because he's accused of embezzlement, he's accused of abuse of office, that is financial impropriety. If a person is accused of committing an offense, the person must be given fair hearing, as the case may be. I will take it etymological view. View of this.
Vincent, I would like to let you.
2 years.
Vincent, my apologies. I would like to let you continue. But unfortunately, we won't be able to. But I might be inviting you over for another show where we can have this discussed much more elaborately.
I just want to say that the Nigerian Bar Association, FMOC, the President of the Nigerian Bar Association, has issued a statement of the standpoint of the NBA condemning the activity that it amounts to judicial rascality and asking NJC to intervene and call the State Assembly to order. And also that any judge of the High Court of Benue State that takes the acting capacity of the office of that CJ should be disciplined, and the lawyer should boycott the state court as a necessary measure against such judge. That the democracy requires that due process must be followed in removing a judicial officer for the democracy to be stable in Nigeria, and for rule of law, and for separation of powers under Section 4, 5, and 6 of the Constitution, wherein the judiciary, legislature, and the executive have different powers. They cannot interfere, as the case may be. The Chief Judge of a state that heads an organ as the last hope of the common man must be given fair hearing and must be removed under the due process of the law.
All right, then, Vincent Ottaokpukpu, thank you very much for, that was plenty. But thank you very much indeed.